Now, you probably don't remember the initial complaint. We did go through it, but the long and short of the initial complaint was that DA Talks, a.k.a. Dean Asaf, and Ethan Van Sciver and Vikkiverse all got together and said some very mean and defamatory things against or about Preston Poulter and a guy named Jon Lamont. So they said some mean things. To give you some background on who all these people are, Ethan Van Sciver is EBS. He has a YouTube channel called Comics Artist Pro Secrets. He is probably the most prominent independent comic creator in the Comicsgate group right now. He was also a DC and Marvel comic artist for a very long time. DC primarily. DA Talks is a Dean Asaf, this is the first document we're going through. He is a YouTuber as well who has been caught up in the comics gossip sphere, as is Vikkiverse. And on the other side of this are two people, Jon Lamont, who is an independent comic artist of some sort. I mean, I don't know if he's independent because he seems dependent on Preston, but maybe, he's not part of a major comic book publishing arm. And then Preston Poulter, who is a very, very weird independent comics artist who is called Peggy for a very specific reason. Peggy is the nickname of Preston because Preston came out as anti-Comicsgate, right? And in the heat of that back and forth where he chose to be the heel of Comicsgate for whatever reason, when he did that, someone went out and looked up his history and found out that he had done pornographic videos with his ex-wife, at the time his wife, in which he would assume the birthing position and she would proceed to puncture his anus with a large implement. Those videos were placed on the internet for consumption, presumably for revenue, on sites like Pornhub and various BDSM fetishist sites. That's how they were found. They were not hacked. They were not stolen. They were not privately made public against their wishes. And then when people found it, it made him very, very, very upset. Jon T. Lamont drew a comic book. And according to the description that was put up on Kickstarter by Jon T. Lamont, the main character of the comic book is a female who is 17 years old, okay? This is an important part of this discussion. It is a 17-year-old minor female. And in this comic book, the 17-year-old female is involved in a sexual relationship with a demonic entity, a succubus, a female sex demon who looks kind of young, but definitely is like 5,000-6,000 years old or whatever. And her name is Lolita. So you have an underage character who's 17, right? And you have a young-looking sex demon named Lolita. And on a live stream talking about it, DA Talks, Vikkiverse, and Ethan Van Sciver in some ways suggested that the art might be a bit creepy, maybe even pedophilic. I mean, just maybe. And I believe Ethan said something along the lines of, I'm going to have to defend the trademark because this is being marketed as a Comicsgate comic or something like that, or they talked about it. And he said, I don't want Preston to publish a book under a pedophile comic book under Comicsgate. Do you guys want to see that? Do you want to see the comic? Should I pull it up to remind you of the top level comic book creation that it was? This is the top shelf comic creation we have going on here. This is the tippity top. This is the Lolita Demon. 4 backers, $26. Boom. Now, notice this was on March 16th of 2021. It was canceled by the project creator. And importantly, this discussion was on April 25th. Here, Emerald May Riley was a typical 17-year-old growing up with her overbearing evangelical father. Blah, 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 blah. She summoned the violent and sex-crazed demon Lolita, who took over her body, murdered her father, and sent her friend to the hospital, with the police and the heavenly hosts quick to track her down. Lolita leaves Emerald's body behind to take the rap and embark on a drug and sex-crazed trip throughout a modern metropolis. Oh, Jesus Christ! Here's the one you really probably kind of need to see. You need to see this one. Very, very uncool, in my opinion, to have this. Shockingly, this magnificent artistry did not do more than $26. Here we go. That is the backstory. What's going on? So we're going to take a look at Dean's answer. And it looks like Dean took this, basically, he's representing himself. Oh, excuse me. And it looks like Dean kind of took a template answer, but maybe from California or something, because this is, it's got some defenses that are under California law as opposed to Texas law. So he's got a bunch of denials, which is the appropriate thing to do in most civil cases, right? You're going to deny the allegations because most of them aren't going to be true. In a federal case, this court has no jurisdiction over DA talks, okay? Let's be very clear. The court does not have jurisdiction over DA talks. This court's in Texas. He lives in California. There's no indication at all that DA Talks did anything directed at Texas. He was making a YouTube video. He's talking about stuff. There's no way that is directed at Texas in any way. But DA Talks answered and did not motion for a dismissal for lack of personal jurisdiction. Defendant denies the allegations set forth by plaintiffs in paragraphs 24 through 38. In that the allegedly defamatory statements are at least substantially true. So it's like, yeah, he is a pedo. What a creep. Statement of opinion. These allegations are, if they're not truthful, then they're just opinions, bro. They're not factual. It's just his opinion that he's a pedo. Now he's got anti-slap statutes as a statutory defense. Federal court in Texas does not recognize state anti-slap statutes. So this defense will not work either. There is not an anti-slap in the Fifth Circuit currently. And the venue is improper for this action. That's true. That is true, but you didn't raise the personal jurisdiction thing, and by the rules, you should have waived it with this filing. This court, or this case, should be thrown out under the 12b6, failure to state a claim. So I'm not trying to harp on DA Talks here, just trying to talk law and let people know what's going on. Here is Ethan Van Sciver's motion to dismiss and brief in support of it. Fighting in Texas is easier for Preston because that's where he is. If he had to sue Ethan Van Sciver in New Jersey, he would have to hire a New Jersey lawyer. He would have to potentially fly out to New Jersey. He would have to fly lawyers out to New Jersey to do depositions. You know, this would be a big thing here. That's why people don't want to fight in different jurisdictions. So I think the personal jurisdiction defense is the proper defense to lead with, even if it doesn't always get you a dismissal with prejudice. A dismissal without prejudice can be sufficiently dissuading to the other party, and you want to take the win where you can get it. Plaintiffs allege only 2 statements made by Mr. Van Sciver were defamatory. He says, number 1, I don't want Preston to make child pornography and put Comicsgate on it. That is not a defamatory statement. I don't know why anybody... there's not even a path to that being defamatory. Like, there are many worse things that could be said that would still not be defamatory. But, yeah. I could... Here. I don't want Preston to make child pornography and put Rekieta Law on it. There you go. That's not defamatory. Finally, we note the obvious. The video was on the YouTube channel Vikkiverse and was viewed by about 750 people. There is no allegation that the channel held itself out as a source of facts like a news broadcast or even a YouTube news channel. No reasonable person would cite to a quote on Vikkiverse as a factual authority. And this is the Rachel Maddow defense, which was fine when Rachel Maddow used it, but was not fine when Tucker Carlson used it in the media. But it's the proper defense. So, you'll note, very importantly, that there are no documents from Vikkiverse, and that is because Preston failed to serve Vikkiverse. Just failed to serve. And may not get to. May have forfeited his ability to serve Vikkiverse by just not pursuing it in a timely manner. This is the problem with that answer, like I talked about earlier. Kundert is evading service. This is not true. You have not actually served Vikkiverse at her address. You served at an address. I think she hasn't been at that address for something like 20 years. That's your fault, you dummy. Evading service that's a pretty serious thing to allege, especially when someone has done nothing to evade the service at all. Here's the problem with the Dean comments. If I'm not mistaken, and credit to Spectre on this, if I'm not mistaken, the stuff attributed to Dean was not said on the YouTube video, and wasn't actually ever said. It was just like aggregated comments that were then interpreted in the way Preston wanted to write them, but they're not actually there. Is what I understand. Plaintiffs also allege that these statements were repeated to an individual named Big Daddy on a public platform. In this instance, there is no specificity as to where it was said. Who's Big Daddy? Who is Big Daddy? Plaintiffs allege that Poulter's most recent campaign suffered a 20% drop in average funding contributions from the last major campaign in November of 2020, but offered no evidence to support this claim. Indeed, Poulter's April campaign for Guinevere and the Divine Factory No. 4 mega campaign has an update stating, "Thanks to all your support, this campaign turned out to be my best launch yet." It seems contrary to plaintiff's claims, these campaigns by plaintiff Poulter have instead made more than the previous campaign, with plaintiff Poulter bragging about its success at the very first update. He continues to attend conventions without worry. Plaintiff Poulter also made posts on Twitter bragging about the amount of sales he was making at all 3 conventions. Taking into account what was said previously about Poulter misrepresenting in the complaint the amount of money made between his November campaign and his most recent campaign as of April 2021 when the suit was filed, serious questions arise over whether Poulter has lost any money. For the reasons above, ASAF moves to dismiss him from the suit because the court lacks jurisdiction and to dismiss the suit in its entirety because of 12b6. Almost triple my table fee on credit card sales alone. The problem you've got here, Preston, is that he's showing the images and deriving an opinion from those images in real time. Like that's happening. That is a problem for your argument. Van Sciver's allies, Dean Asaf, Oh, Ethan, did you know that you are allied now with DA Talks forever? You guys are hand jobbing under the table constantly. Yeah, that's right. Allies for life. Defendants Dean and Victoria are allies of Vansciver. Final document we've got. This is not actually up yet on Pacer. This is the reply from Ethan Van Sciver. You can't find this anywhere else yet. Rather than quote the statement in full, plaintiff represents the statement as follows. That is interesting. You don't want to be caught doing this, by the way. Don't paraphrase when the statement in full is shorter than the paraphrase. So here's the statement in full. Here's the paraphrase, which is longer than the statement in full. Terrible plan. So thank you to Ethan for sending that. I think it's a great brief. We'll see, we'll see how this goes. I have a feeling this case is going to be dismissed on personal jurisdiction grounds in general for Ethan. It should be dismissed. Like, maybe the judge will just dismiss it on 12b6 anyway. But against Ethan Van Sciver, definitely should be dismissed for lack of personal jurisdiction. Against Dean, he technically waived personal jurisdiction. He waived it. So then it goes to 12b6, which is fine. I still think 12b6 applies in Dean's case.